This is Scott Becker with the Becker's Private Equity Podcast. This will also be a special edition of the Becker's Healthcare Podcast. Today's discussion is the FTC's non-compete ban, 5 key questions. We're with Tim Fry today, a partner at McGuireWoods, and he's going to talk to us about what this FTC non-compete ban is and what it's not. We'll go through about 5 key questions. Tim, what did the FTC actually do last week on non-competes? Give us a feel for what actually was passed.
Thank you, Scott. Thanks for having me. Yes, the FTC's own view of the rule that they adopted by a 3-2 vote last week is a, quote, comprehensive ban on new non-competes with all workers, end quote. And it also invalidates most existing clauses that purport to be a non-compete. And so to the FTC, a non-compete is a term or condition of employment. Sorry for the fancy words, I have to get a few legal jargon in, but that prevents a worker from seeking or accepting work or operating a business after the conclusion of the worker's employment. So effectively, Scott, they have adopted a pretty sweeping rule. There are a couple exceptions, which I'm sure we'll talk about, but I think it is fair to say this rule, if it takes effect, if it gets enforced by the courts, will have the effect of invalidating most non-competes, preventing future non-competes, and other items that the FTC has determined is an unfair method of competition. And so in a word, people have called this a ban. I think that's probably appropriate. Certainly the FTC sees it that way, with, again, a few limitations.
Thank you. Let me ask you 2 questions. And for our 2 core audience, at Becker's Healthcare and for Becker Private Equity, does this reach not-for-profit hospitals? Does it reach private equity-sponsored companies?
So the second one, the private equity-sponsored companies, yes. There are probably some nuances in terms of individuals that are owners, not workers, that, again, if enforced, if it becomes effective, will probably be heavily litigated. But certainly if what you're asking is private equity-backed dermatology platform with non-competes against physicians and nurse practitioners, the FTC's intent would be to say those kind of employment agreement non-competes are no longer going to be allowed, absent some extenuating circumstances.
Thank you. And tell us about not-for-profit hospitals. Does it apply to them, where they also employ lots of executives, lots of physicians, lots of others? Does it apply to not-for-profit hospitals?
It's a really interesting question, Scott. And actually, one of your authors at Becker's Healthcare, Alan, wrote a really good piece last Friday that I'd encourage people to go look at. The FTC claims jurisdiction over any corporation which is defined as those that are trying, it's an entity that is conducting business for its own profit or its members. And so what the FTC effectively is saying is this rule applies to nonprofit hospitals, tax-exempt status entities, if they're out to make a profit, not what the IRS rules are. So they'll, at least according to the FTC, some subset of the 58% of hospitals in the United States that are tax-exempt will be subject to this rule. Which are not, will play out over time. Certainly, this is probably one of the broadest and probably most open to dispute in the rule itself, because it's not a clear line. It is not, are you an IRS tax-exempt hospital? Instead, it'll be this other test in the FTC rule. And I think a lot of nonprofit hospitals are going to be looking at that, working with the American Hospital Association, which is very against this rule and this provision. and their legal teams to kind of make a determination of whether they individually will be subject to this ban or not.
Thank you. Another question: are there exceptions to this ban, and what are some of those exceptions?
The two big ones involve senior executives and sales of business. I'll just be very brief on both. Senior executives, the exception only applies to existing non-competes when this takes effect. No new senior executive non-competes after the rule takes effect, but if there is an existing non-compete, it can stay in place. Senior executives has been defined by the FTC very narrowly. They estimate only, less than 1% of all workers in this country will qualify. And they give examples of how physicians, highly compensated physicians, will maybe be a senior executive if they are a partner in a medical practice and they're involved in policymaking for the overall enterprise, but wouldn't if they were the medical director or a leader in one part of the medical staff of a hospital. They wouldn't be deemed senior executives because they're not making policy for the overall enterprise. So it's going to be a very narrow exception. By contrast, the sale of a business exception, Scott, is probably broader. It will allow people to sell their businesses and enter into a non-compete ban for a non-compete clause for a period of time. The FTC, I think, recognized that that protects the goodwill that's part of these sales. But here, they are talking about bona fide sales of businesses. And this could be heavily litigated, especially if we have situations where things like redemptions, or what the FTC calls springing non-competes, are those going to be allowed? Well, the FTC probably says no, they want it to be a bona fide transaction. That doesn't mean courts will agree. So I think the sale of a business concept that they did expand from the proposed rule, where they drafted it very, very narrowly, still has a lot of open questions. And I think we're going to see a lot of case law develop there over time, Scott, again, if this rule takes effect.
And that takes us to the last question, Tim. What are the chances that it takes effect? Will this be litigated? Is it going to stand up? It seems like a very broad effort by the FTC. What are people saying about its chances of standing up?
Yeah, there are actually at least two pretty serious challenges in Texas. One brought by the Chamber of Commerce, another brought by a tax firm in Texas. Both are in front of judges that have done nationwide injunctions on other administrative rules in the past. Nationwide injunction would basically just say to the FTC, you cannot allow your rule to take effect until we're done with this litigation to see if it's constitutional, if it fits what Congress delegated authority to you on. It's also coming at a time when, Scott, the Supreme Court, as you know, is very leery of administrative rulemaking and is likely to, do some new court opinions over the summer that might curtail agency rulemaking authority. So, candidly, I'm telling our clients, take a breath. Look around. We can talk about whether you want to change your strategy with non-competes. There probably are now some reasons that now that the FTC has spoken, that state efforts might change a little bit. But at least with this federal rule, there's probably a better chance than not. I'm not a court prognosticator, but what we're seeing and hearing and seeing the types of challenges that are coming forward. And candidly, Scott, seeing what the FTC wrote about it in its own rule, kind of expecting these challenges, I think there's a really good chance that this is going to be a couple-year process to wind its way through the courts to see if it takes effect.
Thank you, Tim. Thank you so much for joining us today on this special edition of the Becker Private Equity and the Becker's Healthcare Podcast. Again, the FTC's non-compete ban, 5 key questions. Tim, thank you for joining us today.
Thank you, Scott, for having me. And if anyone is interested in hearing about this more, I know Becker's is covering this heavily. We've done an FAQ piece. Just reach out to me by email at tfry@McGuireWoods.com or reach out on LinkedIn, and I'd be happy to provide you more information.